Assalamualaikum warahmatullahi wabarakatuh. So today our group will present our case review and the title of our case is Hijau, Biru, Envirotech Senior Berhad and Tetuan Dzahara Associated, so as a firm and others, 2020 MLJ. So the member of the group in our group is me and myself, Fadila bin Rosli, metric number 2018029.
And me, Muhammad Anwar bin Rosim, metric number 2016971.
Me, Muhammad Izzat bin Ismail, 2013493.
So our content of the presentation today is introduction, the fact of the case, the legal issue, the judgment, commentary, and the conclusions. So as for the introductions, breach of duty occurs when the defendant does something that is perceived to be below the minimum standard of care required of him, which is measured through the standard of reasonable man. As for our case, the area of law involved is the duty of care under the professional defendant. Bankers, lawyers, and all who specialize in particular skill are professionals who are bound to exercise the care and skill of ordinary competent practitioners in their respective professions. The standard of care required of these professionals is that of a reasonable professional would do. Thus, someone who professes to have a special skill will not be judged in the same category as an ordinary person. The standard of care required of a professional is naturally of a higher level than the required of the ordinary man on the street. Then the fact of the case, I'm going to pass to the brother Izzat to present to explain a little bit about the fact of the case.
So this is the fact of the case. Hijau, Biru, Envirotech Senior Berhad hired Tetuan Dzahara and Associates, which is a law firm, in order to file a suit against Sinayah and Sons Senior Berhad, claiming for the outstanding balance of the subcontract work which carried out by the appellant worth 432,442 ringgits. The hearing of the case was held at the Session Court in Melaka. The third respondent, who was also the partner in the firm, Azwan bin Abdul Wahab, had personally handled that case by representing the appellant. The act of the third respondent, which failed to attend one of the hearing of the case, result to dismiss of the case with cause. The first respondent has appealed for an statement of the case, but it failed. After that, the respondent does not appeal to the High Court, instead of filing a new suit, which is suit 18. The new suit was unsuccessful, as the court opined that it is an abuse of the legal proceedings, as the respondent does not use to appeal the first suit to the High Court. As the result, the respondents appeal for the reinstatements of the suit 18 to the High Court, but the appellant suddenly terminated the service of the respondents before the hearing of the case, and filed the writ of summons, which claimed for the negligence of the respondents, as the respondents failed to attend the hearing of the case and their failure to continue the legal proceedings. The Session Court held that the respondent was negligent. The judge stated that the respondent caused the appellant lost the opportunity of getting back the balance amount from the Sinayah. He also opined that there was a big opportunity to win if the respondents appealed the first suit to the High Court. Unsatisfied with the Session Court judgment, the respondent appealed to the High Court, which later allowed the appeal and reversing the Session Court judgment. In allowing the appeal of the respondent, the High Court judge stated that the appellant had wrongly terminated the service of the respondents. He also opined that the absence of the respondents from the hearing of case was caused by the appellant's negligence. Thus, the appellant appealed to the High Court, which is the current case that we are studying. In this appeal, the appellant claimed that the respondent has failed to appeal to the High Court for the first suit, which was struck out by the Session Court. The appellant also claimed for the negligence of the respondent, who failed to appeal the first suit to the High Court in order to reinstate the first case instead of filing a new case, filing a new suit, which is suit 18.
Now, for the legal issue, I will discuss it. Now, the legal issue for this case in the Court of Appeal is whether the High Court judge erred in finding the appellant had wrongfully terminated the service of the respondents. Looking at all the circumstances, it was apparent that the request for adjournment of the trial date was mishandled. It was clear that if the request for an adjournment of the trial date had been put in writing and the conversation with the opposite side's counsel confirmed in writing, the respondent may well have stood on firmer ground when applying to reinstate the part heard case in the first suit. Further, after the reinstatement application was dismissed, the respondent chose not to appeal to the High Court and instead filed suit 18 against Sinaya, which was then struck out as being an abuse of process. The respondents could and ought to have appealed to High Court against the Session Court's refusal to reinstate. The respondent could state. However, the respondent chose not to take the road of appealing to the High Court and, if necessary, to the Court of Appeal. In doing so, the respondent had effectively deprived the appellant of 2 rounds of appeal and thereby squandered the opportunity to resurrect the appellant's chance of continuing with their claim against Sinaya. In the present case, the failure on the part of the appellant to call an advocate and solicitor to testify on how a reasonably incompetent advocate and the solicitor would have handled the situation was not fatal on the issue of breach of standard of care of a reasonable competent advocate and solicitor. However, apart from the initial negligence of not attending court, the respondent had compounded or aggravated their initial negligence by taking the road of not failing an appeal against the dismissal of the reinstatement application and proceeding instead to file suit 18. Ultimately, by their various action and inaction or inadequacy, the respondent had decimated the appellant's chance of recovery against Sinaya. In the event, there was clear and unmistakable finding of professional negligence by the Section Court judge in the negligence suit commenced by the appellant, and those findings are clear, cogent, and convincing. As such, there was no appealable error or any misdirection by the Section Court judge in her conclusions as to the respondent's liability for negligence. The High Court judge had misdirected himself in admitting that the ASDB order and in relying upon the same in exonerating the respondents of negligence. Critically, the ASDB order was irrelevant as the Section Court judge and or the High Court judge were not bound by the finding of the ASDB. Consequently, the High Court judge was wrong in his approach and assessment of the issue on appeal before him. Now, for the judgment, in this case, the court allowed the appeal and the decision of the High Court is set aside. Consequently, the decision of the Section Court date 26 March 2018 is reinstated. The first and second respondents are to jointly and severally pay costs of 15,000 ringgit Malaysia, subject to allocator, as costs here and in the High Court. Now, I will pass the next commentary part to my brother Afadillah.
So as the commentary, in our opinion, we agree with the decision made by the Court of Appeal, which allowed the appeal, and the decision of the High Court was set aside. It is all based on all of the case referred by the court. The decision derived from the case of Lembaga Kemajuan Tanah Persekutuan Felda and Awang So bin Mahmad and another 2009 MLJ, who is a reasonable, competent advocate and solicitor who represent a client in court proceeding must not only be up to date with the law, but must also perform the most basic fundamental or rudimentary duty of attending court on the hearing of the case. It is stated that the most dreadful situation for any advocate and solicitor is where the action is struck off due to the counsel's absence. Then it was contended on behalf of the appellant that the fact that the respondent filed suit 18 did not and should not make a difference, as it was clearly an abuse of process of the court as referred to the case of Punch Lloyd Oil and Gas and Etika Insurance Berhad and another 2015, and the case of Lim Oh and another and Ellen and Gladhill, which is the appellant in this case, ought to have appealed against the decision striking their first suit for disobedience of the peremptory order, the filing of the second suit containing as it did the same issue and relief as the first suit amounted to a deliberate attempt to circumvent the necessary appeal procedure and therefore constitute an abuse of the process of the court. Lastly, regarding the rejection of the ASDB order is made by the court is based on the judge's view that the learned judge had misdirected himself in admitting the ASDB order. And in relying upon the same exonerating the respondent negligence, the judge said that the ASDB order was totally irrelevant as the session judge court and the learned judge were not bound by the finding of ASDB order. Therefore, it is undeniable that the judgment of our case and the reason behind the judgment were reasonable. To conclude our presentation today, we can say that the judgment of this case can be considered as a good law and can be one of the leading cases regarding the negligence in law profession to prevent breach of duty of care among the lawyers. So that's all from us for our case review presentation today. Thank you.